o'clock. If it's possible to keep...
How you going, people? I'm listening to the opening arguments, and then I'll kind of evaluate some things said and done on this George Floyd case, where George Floyd was committing criminal acts, trying to pass counterfeit money, a counterfeit check. He was in possession of drugs. He had 10 times the fentanyl dose in his body that was going to kill him. He fought with cops. He had been to prison, had extensive criminal history, and now they're charging the officer for arresting him. So that sounds a little skewed. I just had to give the other side, because if CNN says it, poor George Floyd was out trying to save his brother's life, and the cops just beat him up and killed him. So I had to give the other side. Now, so far, this judge has been very...
Okay, the judge saying they're going to take a little bit of a break.
Anytime there's cameras, judges just turn into freaking, you know, like there's this new control. I mean, this judge has been talking about opening, and I mean, normally opening statements are pretty self-explanatory. You go up, but because there's cameras in there, all the lawyers have to say something. Then the judge has to respond and clarify, and it's just... I mean, you know, I believe in transparency. I believe in cameras. I think witnesses make people honest. I would love people to learn the inside of a court and watch courts. Most people don't go to court. Most of it's boring. But if you've been inside a courtroom, you see the games and the lies and the mistruths and the misdirection and the politics, you would rapidly lose faith in the system. But and that's why government doesn't want cameras in all courtrooms all the time. Because they know you would see the incompetence of judges, lawyers, and the crazy crap that goes on. So I'll pause it till they start opening statements.
The facts, and I will be the judge of the law. I'd ask everyone in the courtroom to stand while the oath is being administered. Raise your right hand, please. Do you swear or affirm that you will be attentive during this trial and follow the instructions of the court so that you may reach a fair and just verdict, that you will not discuss this case with anyone until submitted to you for deliberation, and will keep your verdict secret until it is delivered to the court? If so, say I do. Thank you. You may be seated.
So they're not showing the juror. You know, there's the Black Lives Matter people outside protesting, saying all they got to do is show the video and the case is over. Just show the video and be done. Find him guilty. So they don't really want a fair trial. They just want, you know, a kangaroo court to convict somebody that they don't like. Man, this guy can't get a fair trial. It's crazy.
Device. All right. No hands. If during the trial, at any time, you have difficulty hearing or understanding what a witness is saying, or if a witness or attorney should block your view, please raise your hand immediately so that we can correct the problem. Now, during the trial, you are going to hear the testimony of several witnesses. You will have to make judgments about the credibility and the weight of their testimony. Be patient and listen to the testimony of all the witnesses. Keep it all in mind until you have heard all the evidence. As you listen to the witnesses, you should take note of such matters as the witness's interest or lack of interest in the outcome of the case, the ability
that goes to bias,
to know, remember, and tell the facts, their experience, frankness and sincerity, or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence, and any other factors that bear on the question of believability and credibility. In the last analysis, you should rely on your own experience, good judgment, and common sense. Now, you have been given notepads so that you may take notes during the trial. You should not, however, feel required to do so. The most important thing is that you give full attention to the testimony as you hear it. Now, to protect the privacy of your notes, I would suggest you write your random juror number, which we will keep the same, and put that on the first sheet, and then begin taking notes on the second sheet. We also have extra pads if you run out of space. Now, we will collect and keep your notes secure at the end of each day, so you can leave them on the chair during breaks and at the end of the day. At the end of the trial, you will be allowed to take your notes with you into deliberation, and I will instruct you further regarding the use of those notes at the end of the trial. Keep in mind also that I cannot give you a trial transcript at the end of the trial. No such transcript can be prepared for your deliberation. We count on the jury to rely on its collective memory and the exhibits submitted to you. Now, during the trial, an objection may be made to some evidence, and I may sustain or overrule the objection. If I sustain the objection, it means that the question may not be answered. In that case, you should simply ignore the question and any answer that might have been given. If no answer was given before the objection was made, you should not speculate about what the possible answer might have been. Similarly, if I instruct you during the trial to disregard some statement that a witness or attorney has made, then you must disregard it. If I overrule the objection,
You can't unring a bell, and lawyers know that, so they don't care if they lose the objection. If I can ask a question or provoke a thought, the term is you can't unring that bell. Even though the judge says, disregard that, attorneys know that I can plant the seed in your head.
scheduling matters with me. If these discussions are brief, the lawyers and I will use the wireless headsets while the white noise is on. If the discussions are lengthier, I may take a recess. Please understand, we are not attempting to conceal anything from you
Bullshit.
necessary for you to hear. I ask that you be patient when we have these discussions, even though they may interrupt the case. And just as an aside, we are scheduled to have the time between 8:30 and 9:30 every morning set aside for the lawyers to argue legal issues. So hopefully we can handle most of that before we start again at 9:30 each morning. Now, when I turn on the white noise, that's your indication that the conversation is not for you. So please, do not attempt to listen in, and please come to order when I turn the white noise off. And I'm also giving that instructions to anyone who's a spectator here. The white noise is a private conversation, usually about scheduling, nothing exciting, between me and the attorneys. You can use that opportunity, however, if you'd like, to stand up, stretch, talk to your neighbor. But if you could, make sure you don't, there's a piece of black tape in front of you. Please don't cross that line. We've taken great care to make sure you are never on camera. And so as long as you stay behind that black line and even the stretch in the aisle between, you should be just fine. Now the cameras have been angled so that, as I said, you'll never appear on video. To assist in that, do not cross the black tape, and when entering and departing from the courtroom, please use the aisle between the two rows of seats. And do not get out of your seat until the deputy is at the door waiting to escort you back to the other room. Now, there's things you should not do during this trial. As I said during jury selection, you are not investigators. You are not to go out to do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. You should avoid all news if possible, but at the very least, you should avoid media coverage of this case. Remember, you must not talk to anyone who is involved in the case, the attorneys, the witnesses, or spectators. Do not be offended if they do not speak to you. They know that it would be improper.
They know. I told a story a couple times where one of the DAs at Yolo County, actually, Jeff Reisig, the DA there, was this guy's best man. They're buddies because they're both unethical. This guy doing a jury trial, you just heard him tell the jurors, don't talk to the attorneys about the case. This DA asked this juror out while she was on trial, got her number, took her out, had sex with her, ended up marrying her. All while the trial, well, he didn't marry her while the trial was going on, but all this went on while the trial was going on before she gave her verdict. Raise your hand if you think she ruled against the DA that she was sleeping with. Well, if your hand's up, you know the answer.
Probably have figured it out by now. But in any case, feel free to share with them, but no one else. As I stated before, since this is all you should tell family and friends, that is all you should tell the general public. So during trial, please refrain from using Facebook or Twitter or any other social media to comment on this trial. You may access such internet apps and tools, but please do not publish any information about this case.
Remember, they've got cameras on lapel mics, on glasses, on watches. So I'm surprised these jurors' ID have not been leaked yet.
Please disable any news feeds that might show up on your social media accounts that might report on this case. As I told you during jury selection, this case is being televised, but you will not be shown on video. Now, there are certain things you should do during trial. The first of all is to be on time to report for court. We cannot begin unless every participant is present. And while waiting for court to begin, please wait in the other courtroom until one of my clerks or a sheriff's deputy brings you into this courtroom. As I've said, the time that we have set aside for the lawyers and I to discuss legal issues from 8:30 to 9:30 means that we'll start with you at about 9:30 every morning. Nevertheless, there still might be unexpected delays. We'll do our best to keep on this schedule, and generally we will go with the jury from 9:30 to 12:30 with a 20-minute mid-morning break. And we'll take your orders for lunch because we will be providing you lunch throughout. Court will usually start again at 1:30 or 2 p.m. and go until about 4:30 or 5 p.m. with a 20-minute mid-morning or mid-afternoon break. To some extent, this may seem leisurely, but before and after court and during the breaks, the attorneys are preparing for the next session of court. Please turn off all electronic devices such as cell phones and computers while the court is in session. You may use such devices outside this courtroom when you are on a break, but please remember to turn them off while in this courtroom. I will allow you to bring water, coffee, or other beverages with you during the trial. But to keep noisy distractions to a minimum, please open any containers before we resume court and not while evidence is being taken. Now, if a problem should arise during trial, or you observe what you believe might be improper conduct, and you need to bring this to my attention, please contact my clerk or one of the deputies. They will communicate your concerns to me, and we will do our best to handle the situation. Make a mental note of the seat in which you are sitting right now, and please keep that seat throughout the trial. We will begin with opening statements. In the opening statements, the attorneys may describe for you what they believe the evidence in this case will be. Evidence is what the witnesses say, and any exhibits submitted to you. What the attorneys say, however, is not evidence. Anything shown to you in opening statements is also not evidence unless and until it is actually received in evidence during the trial. You should keep an open mind about all the evidence until the end of the trial.
Opening statements are usually kind of interesting because some people say you win or lose on an opening. Other people say you win or lose on your closing. I think closings are more important because that's the last thing they hear. Opening statements get kind of lost and forgot because there's so much minutia in between about objections and evidence and statements and different witnesses and don't remember this and you can't do that. So opening statements tend to fade a little bit, but there's some people that say you can win on a good opening statement.
May it please the court, counsel. Ladies and gentlemen of the jury, good morning. My name is Jerry Blackwell, and I apologize for talking to you through this plexiglass, but it's probably the least of the gifts that the pandemic.
You think they picked a black prosecutor by accident or by random?
A lot about what it means to be a public servant and to have the honor of wearing this badge. It's a small badge that carries with it a large responsibility and a large accountability to the public. What does it stand for? It represents the very motto of the Minneapolis Police Department: to protect with courage, to serve with compassion, but it also represents the essence of the Minneapolis Police Department approach to the use of force against its citizens when appropriate. A sanctity of life and the protection of the public shall be the cornerstones of the Minneapolis Police Department's use of force. Compassion, sanctity of life, cornerstones, and that little badge is worn right over the officers.
This sounds real good now, but why don't we see this on all the other cases of police brutality? Why do we only see this officer being charged? Ask yourself that, old wise one.
When they become police officers, they take an oath that I will enforce the law courteously and appropriately, and as you will learn, as applies to this case, never employing unnecessary force or violence.
Yeah, we've never seen that by any cops. Really? Really?
Office as a symbol of public faith, and I accept it as a public trust to be held so long as I am true to the ethics of police service. Symbol of public faith, ethics to police service, sanctity of life, all of this matters tremendously to this case, because you will learn that on May 25th of 2020, Mr. Derek Chauvin betrayed this badge.
Wow, betrayed his badge. Woo! Coming on strong. Punch him out the get-go gate.
Put his knees upon his neck and his back.
Put his knee on his back like the policy of the Minneapolis Police Department said he could do. Left that part out. I showed the policy. He was within policy. But it doesn't matter because he did the policy to the wrong person in front of the wrong people.
Well aware that Mr. Floyd was unarmed, that Mr. Floyd had not threatened anyone.
A lot of people thought his hand was in his pocket. His hand is not in his pocket. He's got a black glove on, people.
In that 9 minutes and 29 seconds, the most important numbers you will hear in this trial are 929. What happened in those 9 minutes and 29 seconds?
The people protesting outside, their masks have 929 on them. So they're making this the big key. This is like the smoking gun is the time. First of all, 9 minutes isn't that long. And George was fighting for most of those 9 minutes. Now, granted, he stopped fighting at the end, but he was fighting for most of them.
Ladies and gentlemen, is to bring you the evidence, which I'm trying to preview this morning. We are bringing this case, this prosecution against Mr. Chauvin, for the excessive force that he applied onto the body of Mr. George Floyd, for engaging in behavior that was imminently dangerous, in the force that he applied without regard for its impact on the life of Mr. George Floyd.
Mr. George Floyd, not convicted felon, out on parole, committing crimes his whole life, under the influence of drugs, committing a felony when this happened, and resisting arrest, George Floyd. Just Mr. George Floyd. Okay, I got it.
I can't breathe. Please, man, please. In this 9 minutes and 29 seconds, you will see that as Mr. Floyd is handcuffed there on the ground, he is verbalizing 27 times, you will hear. In the 4 minutes and 45 seconds, I can't breathe. Please, I can't breathe. You will see that Mr. Chauvin is kneeling on Mr. Floyd's neck and back. He has one knee on his neck, and the knee on his back is intermittently off and on his back, as you'll be able to see for yourself in the video footage. You will hear Mr. Floyd as he's crying out. You hear him at some point cry.
They keep wanting to program this image. Show the image. Make sure the jury remembers this. The more we show it, the more the jurors will ignore everything else and only remember this. These are what I call sneaky lawyer tricks.
You will hear him crying out, and you will hear him cry out in pain. My stomach hurts. My neck hurts. Everything hurts. You'll hear that.
Maybe it hurt because he's been doing drugs his whole life and he was fighting and he had a bunch of fentanyl in his system and methamphetamine and marijuana, and all the poly drug use were interacting, causing all kind of chaos in his system, which could have resulted in why he died. No, Rick. It's because the white man put his knee on a black man. Okay, I got it.
Before that time, you'll hear his voice get heavier. You will hear his words further apart. You will see that his respiration gets shallower and shallower, and finally stops when he speaks his last words, "I can't breathe." And once we have his final words, you'll see that for roughly 53 seconds, he is completely silent and virtually motionless with just sporadic movements. You're going to learn those sporadic movements matter greatly in this case because what they reflect. Mr. Floyd was no longer breathing when he's making these movements. You will learn about something in this case called an anoxic seizure. It is the body's automatic reflex when breathing has stopped due to oxygen deprivation. We'll be able to point out to you when you'll see the involuntary movements from Mr. Floyd.
I wonder if they're going to go into how 5 times the legal amount of fentanyl in your system affects that little system. We'll see.
When blood is no longer coursing through the veins, you will hear the body gasp as an involuntary reflex. We'll point out to you when Mr. Floyd is having the agonal breathing, again, as a reflex, involuntary reflex to the oxygen deprivation. So we learn here that Mr. Floyd at some point is completely passed out. Mr. Shaba continues on as he had, knee on the neck, knee on the back. You'll see he does not let up and he does not get up. For the remaining.
Now I'm a little confused on what all these people are typing. If these guys are reporters or if these are paralegals or other attorneys and what they're typing is showing up here. When I was typing for my attorney, I had a separate laptop, and when a case was going on, I would be typing questions or things that are wrong, and then the attorney would just read my screen. I'm sure now that when she types, it could be popping up in a little screen on one of these attorneys for them to read notes to spark their memory. If that's who they are, I don't, they're sitting behind these guys. I don't have a clue on who all these people are typing. Normally, there's one person typing who is a court reporter, and I don't know who the hell all these people are. Nope, maybe I paused it too long. Crap.
Have taken the gurney out of the ambulance, have rolled it over next to the body of Mr. Floyd, and you'll be able to see Mr. Chauvin still does not let up, doesn't get up. And you will see it wasn't until such time as they want to move the lifeless body of George Floyd onto the gurney. Only then does Mr. Chauvin let up and get up, and you'll see him drag Mr. Floyd's body and unceremoniously cast it onto the gurney.
Oh, so it was unceremoniously. Maybe it should have been with respect and with dignity and with honor, because this guy was a convicted felon committing a felony at the time, resisting arrest. Maybe he should have treated him like he was a god. Because why?
Gentlemen, not just Mr. Floyd. You're going to hear and see that there were any number of bystanders who were there, who were also calling out to let up and get up, such that Mr. Floyd would be able to breathe and to maintain and to sustain his life.
Picture.
But then for the remaining 4 minutes and 44 seconds, Mr. Floyd was either unconscious, breathless, or pulseless. And the compression, the squeezing, the grinding went on just the same for the total of 9 minutes and 29 seconds.
Now, for y'all that think I'm just being one-sided here, I just want to give the other side that you're not going to hear anywhere else, and a little bit of the cop's perspective and how biased this court is. But when I first saw this video, I did a video on this, and I thought it was kind of outrageous that he laid on him for as long as he did. Do I think he should go to prison for it? No. It has nothing to do with color of the victim or the cop. It has to do with the conduct of the criminal who was committing the felony, who was resisting, caused most of this. Now, could the cops have done a better job? Absolutely. Should cops be held accountable? Absolutely. But all cops across the country should be, not just ones that fit a political agenda like this.
that it has to be evaluated from moment to moment. You'll also learn that the Minneapolis police are precluded, not allowed, to use any more force than is necessary to bring a person under their control.
Oh my God, if this prosecutor had any credibility, he would be prosecuting 90% of the cops that charge people with resisting arrest for doing this. But he doesn't have credibility because this isn't about justice or the law or the policy as much as they want to make it out to be that. This is about a witch hunt.
Or putting his or her life in danger. The evidence is going to show you that there was no cause in the first place to use lethal force against a man who was defenseless, who was handcuffed, who was not resisting.
He was resisting. It wasn't lethal force. Nobody used lethal force on him. Nobody shot him. But anyway.
The force against Mr. Floyd should have ended as soon as they put him on the ground in the first place.
Oh, sure, because he would have just laid there. It wasn't like he was trying to climb out of the car and push his way out of the car, and he wasn't twice as big as all the officers. No, 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 no. They should have just put him on the ground and stopped using force, because he would have stayed there, and the fentanyl and drugs would have made him very compliant. Come on, people.
We're also going to learn about another very important policy in the Minneapolis Police Department. That's a core principle of policing.
Core principle. Really? What is that?
You will hear this phrase that police have to live by in terms of how it is they relate to the public.
Sure.
In your custody is in your care. In your custody is in your care. Meaning that if you as an officer have an individual, a subject that's in your custody, it is your duty to care for that person. And you will learn that caring, ladies and gentlemen, is not a feeling. It's a verb. It's something you're supposed to do to provide care for that person. You are going to hear from any number of police officers who will talk about this duty to provide care. Officer Nicole McKenzie, who is the Minneapolis Police Department Medical Support Coordinator. You'll hear from Sergeant Kerr Yang, the MPD Crisis Intervention Coordinator. In your custody is in your care. You're going to learn that when Mr. Floyd was unconscious, that when he was breathless, when he did not have a pulse, that there was a duty to have administered care, to let up and get up.
That duty to administer care has to be done once the situation is secure and officers feel that it's safe to do so. You know, if a guy's got your gun and you shoot him and he still has your gun, you're not required to administer care while he still has your gun and can shoot you. But again, they say these terms to people on the jury that don't get it, and they're just pushing an agenda to push their agenda. This guy wants to win. These guys want to win. They're both attorneys. And then they want to put on a show for everybody on how, you know, the court system works and how great it is and how this has nothing to do with bullshit politics. This is about holding police accountable. Bullshit.
To talk with you. Her name is Genevieve Hansen. She wanted to check his pulse. She wanted to check on Mr. Floyd's well-being. She wanted him to let up and get up. She did her best to intervene, to be able to act, to intercede on George Floyd's behalf, and you'll be able to see for yourself when she approached Mr. Chauvin on top of George Floyd with both of his knees, reached for his mace in his belt and pointed it in her direction. So she couldn't help. She'll come and talk with you about that experience. Now, you're going to learn that in the aftermath of this, that Mr. Chauvin's last day of employment with the Minneapolis Police Department was on May 26th of 2020. The Minneapolis Chief of Police, Chief Arredondo, is going to come here to talk with you. He was the police chief at the time. He's the chief today. He is going to tell you that Mr. Chauvin's conduct was not consistent with Minneapolis Police Department training, was not consistent with Minneapolis Police.
Of course he's going to say that now. because he doesn't want riots in his city, and he's been told by the chief that we have to support and we have to look non-biased, and the prosecution has to be black. I mean, the prosecution has to have our cooperation so we can fool all the idiots out there that thinking, oh yeah, there's nothing to see here. What a scam.
Well, you're going to learn that it was about a counterfeit $20 bill used at a convenience store. That's all.
That's all. It's a felony. It's a burglary felony. He entered with the intent to use this and commit a crime. That's a felony. He was in possession of methamphetamine. That's a felony.
You will learn that even if he did it on purpose, it was a minor offense, a misdemeanor.
Minor offense. So if somebody comes up and takes your $20, it's just minor. You should just let him go, right? He's a good guy. So what? He's been in prison. So what? He's under the influence of drugs. So what? He's going to resist arrest. You should just give him your money. It's only $20. It's a minor offense. Really?
Murder in the third degree and manslaughter for using excessive force against George Floyd. You will learn that the use of excessive and unreasonable force against the citizen is an assault. In this case, we will show you that this was an assault that contributed to taking his life, an assault. We're going to show you that putting knees on somebody's neck, Mr. Floyd's, putting a knee on his back for 9 minutes and 29 seconds was an eminently dangerous.
They're going to say that he had his knee on his back, and because of George Floyd's resistance and movement and trying to get up, periodically the knee slid down to the neck. But the officer was following policy and trying to keep it on his back, even though I think the policy said it's okay to put it on the neck.
Of use of force, let alone for 9 minutes and 29 seconds. Now, how are we going to prove these charges? We're going to prove it, ladies and gentlemen, first and foremost by witness testimony.
Did he say ladies and gentlemen's?
Referred to normal folks. They'll tell you what they saw. They'll tell you why they stopped. They'll tell you why they were concerned. They'll tell you from that witness chair. We'll bring them in here. You're going to hear from any number of police officers.
See, when you start talking like this shit, jurors are starting to tune off like, dude, we get it. Can we get on with the trial? Quit telling us what we're going to see, we've already been told that we can't use anything you're saying as evidence. Why are we having to sit here listening to your babble? Attorneys think they're important, they're wonderful, and they want to bond, and this is a bonding moment. They are setting up their case, and they are doing... As a juror, they're just like, dude, just get on with the freaking case.
Who studies the tissues of the deceased as a forensic pathologist to determine the cause and manner of death. You're going to hear from a pulmonologist, Dr. Tobin.
Just from a safety point, there seems like a lot of wires there. Who's in charge of safety? Somebody's going to trip. Everybody should have a helmet on in here so they can be safe. You got to have a mask on. What about tripping over these wires? Somebody banged their head and killed themselves. Next thing you know, we'll be having a trial on that.
We're also going to bring in the court Dr. Andrew Baker, who's the Hennepin County medical examiner, who will tell you about what he found. So we'll also bring him in.
See, when he tells them who they're bringing in, he's getting their name, and then he tells them what they're going to say, even though they may not say that exactly, but he's planting seeds. See, when I was in that trial and going against that dirty DA, they brought in a lieutenant and said that me and my lieutenant said that you could see a round fired at night from that distance. We never said that. But the lieutenant got on stand, said that, the jury heard it, everybody else heard it, and then they never called us to hear it from us. So those are tricks that lawyers play. He gets to sit here and tell you what they're going to say. A juror may remember that, even if he doesn't say it when he gets on a stand.
Decisions, they sometimes have to make split-second life and death decisions. In this trial, you're going to meet any number of the men and women from the Minneapolis Police Department who do a fantastic job. They're committed, take very seriously preserving the sanctity of life.
They're all heroes.
I mentioned already Commander Katie Blackwell, Sergeant Kerry Yang, Officer Nicole McKenzie, to name a few. This case is about Mr. Derek Chauvin and not about any of those men and women, and it's not about all policing.
You know why it's not about all police or all those other people? Because those people work for the prosecution and they're against the guy on trial. That's why it's not about them.
9 seconds, not a split second among them. That's what this case is about. You are going to hear from one of the bystanders, Charles McMillan. And Charles McMillan is going to talk to you about the excessive force that he saw Mr. Chauvin displaying.
He doesn't know what excessive force is. He's civilian. He has no idea. Has he been through the academy? Has he had the training that a police officer? I mean, his testimony is bullshit. He's no more of a witness than everybody that saw the video. Let's call in the millions of people that saw the video and testify how it was excessive. How is that proof of anything?
You will be able to observe Mr. Chauvin's body language for yourself in the video and determine what that language says to you.
Oh, so now we're going to know what his body language says. Wow. Man, this is going to be good.
That the video is graphic, that it can be difficult to watch. It is simply the nature of what we're dealing with in this trial, ladies and gentlemen. You're going to see any...
Are those leopard slippers? What the hell? I'm sorry, I got distracted.
But you're also going to see videos from the bystanders. Normal folks, the bystanders. You're going to see these bystanders, a veritable bouquet of humanity, these bystanders. You'll see here a little girl who's wearing a green shirt on the right with the words love on the green shirt.
Oh, she had a green shirt with love. That means whatever she says must be true. And you have to believe it, right? What the hell does that have to do with evidence?
Talk to you. Cousin was taking the younger one to Cup Foods to be able to pick up candy and snacks when they came up on.
Oh no, we got another death because somebody went to the store to pick up some Skittles and he got killed by the police. And now some kid went to go get candy and they saw it. Oh.
The young woman in the blue pants is Genevieve Hanson, the first responder who tried to intervene to check his pulse and to check on Mr. Floyd. She's going to come and testify to you. Next to her is a young man named Donald Williams, trained at the security.
Now look, when these witnesses come on a stand, if they say something credible, I'm okay with that. Again, I'm being critical because I think this is a dog and pony show and it's bullshit, but do I think cops ought to be held accountable? Hell yeah. If you go watch my playlist on Earning the Hate, I'm always cracking on cops doing bad. There are so many cops that have done so much worse than this guy, and they don't get shit because it's not politically correct.
They tried to first, you will learn when you meet them, to intercede on what was happening with their voices. They tried to interject, to exhort, to plead.
Actually, they tried to interfere with the officers. Isn't that what we're told? When you start screaming or interfering with an officer, you'll go to jail for obstruction. But when these people do it because they want to use them, suddenly they're heroes and they were doing the right thing. So now we know that it's okay to yell at cops and to tell them to stop and to speak out when cops are doing their job. Perfect. This case can be used for that.
Would not be misrepresented such that it could not be forgotten. What we'll see this morning will be the footage taken from one of these bystanders in just a moment.
Anybody else thinking of Ronald McDonald?
And you will learn with respect to these bystanders that none of them knew who George Floyd was. They didn't know his history. They didn't know anything about it. All they knew was they came up on an individual that they saw was in some serious distress under the knees of Mr. Chauvin, and it alarmed them. Let me show you what the scene looks like just briefly. Here in Minneapolis, this takes place at the intersection of Chicago Avenue and 38th Street at Cup Foods. If you can see the image of a squad car on Chicago Avenue, that is ultimately where Mr. Floyd was being restrained on the ground, under the knees of Mr. Chauvin. We will spend quite a bit more time with this map during the trial, but just for now, I just wanted to try to set the stage for what you're going to see. So with that, I'm going to show you the video evidence. And the video evidence, I think, will be very
Is he going to show the video evidence now? Because they're going to show it now. They're going to show it during the trial. They're going to show this video, I'm going to guess, a minimum of 10 to 12 times during this trial, if not more.
I thought they throwing people out here. Got him beat on the ground.
Please, 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 I can't breathe. Please, man, please, somebody help me.
Could it be he couldn't breathe because he had fentanyl in his system and he had been fighting for the last 5 or 10 minutes? Could that be why he can't? No, Rick, he couldn't breathe because the cops were kneeling out. Oh, okay, I got it.
You got him down, man. Let him breathe, at least, man. I can't breathe. I've been trying to help out. So let him breathe a little bit more.
Okay, here his knee is clearly on his neck, and I can't remember the policy. I'm assuming the defense is going to show the policy, but this right here looks pretty aggressive, and it looks like he's going to hurt him. It doesn't look good, and when something doesn't look good and then somebody dies, it's an easy jump to say, you did it, you're the cause, it's your fault. Remember, this cop wouldn't have been here had he not been committing felonies. I know the attorney said it's a small crime, but had he not been committing felonies, none of these cops would have been here.
Water, something. Please. Please. I can't breathe, officer.
Shut up.
They're gonna kill me. They're gonna kill me, man.
Look, this video looks bad. I mean, there's just no way around it. It looks bad. But, I mean, I don't even know what to say. I mean, it just looks bad, and the guy ends up dying. Should he have died for committing these felonies? No. I've never said that. Now, of course, Black Lives Matter will come here and call me a racist and say I wanted him to die, but that's not the case. My issue with this trial is I see cops do this all the time, and the cops don't get charged. Why are they trying to put this cop in prison? Because he's black and he's white. That's what this boils down to. And I don't like crimes based on color. I don't like convictions. I don't like black people going to jail because they're black. I don't like white people going to jail because they're white. I don't think that's what our criminal justice system should be. Some people are okay one way and not okay with the other.
Bro, he ain't crying, bro. You circle like in a jiu-jitsu move, bro. You trapped in his breathing right there, bro. Like you don't think that.
Big problem here is we don't know how much force he's putting here. There's no way to tell. I'm sure they're going to get some physic guy in here to say, well, with his weight and his hands and the angle of what he's leaning, and you can tell by the toe on his foot that it was approximately 42 pounds, which is enough to block the airway. You know, they'll probably get on all this, but I can kneel on somebody and I can put less pressure or more pressure. I can go out to my scale right now and kneel down on it, and I can show 10 pounds, or I can show 20 pounds, or I can show 30 pounds, all by making very small adjustments to my weight. That's a problem if you're going to get down to how much weight was he putting on his neck.
You know it's bogus. You can't even look at me like a man because you a bum, bro. He's not even resisting arrest right now, bro.
Now, I don't know if he's cuffed yet or not. If he's cuffed and he's doing that, man, it looks bad. It's excessive.
Bro? You think that's cool right now, bro?
I said that from the beginning. I thought he used excessive force. Did his excessive force kill this guy? If he hadn't had all the drugs in him, I still wouldn't be 100% that he killed him. But if he didn't have all the drugs in him, I think the case against him would be much stronger. Because now it switches the burden of proof on, if it wasn't you, what killed him? Now what we have is the drugs were going to kill him anyway. Therefore, did the drugs kill him or did you kill him? Or did what you did speed up the drugs killing him? So it just makes it muddy.
Check on him. He's not responsive right now.
Back off.
He's not
Look at him.
right now.
Get off the street.
He's not responsive right now.
You would know
He's not responsive right now.
Okay, we're going to see this video a bunch of times. I'm at 44 minutes. I'm going to end this, or 45 minutes, and start another one so we can make these different.